Okay, let's unpack this. Ever feel like trying to understand government support schemes is like being handed, I don't know, a puzzle with a million tiny similar looking pieces?
Mm.
It's important, but, well, where do you even start? You're definitely not alone. And
No.
that's exactly why we're taking a deep dive today into a really significant piece of the Australian support landscape, the National Disability Insurance Scheme, or NDIS.
Yeah.
Think of this as us sort of sorting through that puzzle for you, highlighting the key shapes and, how they fit together.
That's a great way to put it. For
Mm.
this deep dive, we've got our hands on a pretty comprehensive resource,
Yeah.
the National Disability Insurance Scheme Handbook.
Right.
It's essentially the official guide, pulling directly from the legislation and all the rules that govern the NDIS.
Hmm.
So our mission today is really to extract that core information, make sense of what can definitely feel like a complex system,
Mm.
and give you a clear understanding of the NDIS, whether you're thinking about applying, maybe you're already a participant, or you're just curious about how it all works.
Exactly. And we're not just going to, read from the handbook. We're here to highlight what truly matters, try and clarify the tricky parts, and give you some real insight into the mechanics of the NDIS.
Wow.
We really want you to finish this conversation feeling, well, informed and with a solid grasp of the NDIS essentials. So it's such a detailed scheme. Where should we begin? Where's the best starting point for this discussion?
Well, a logical place to start is usually with who can actually access the NDIS. The handbook outlines three fundamental criteria: age, where you live,
Hmm.
so residence, and whether you have a disability or perhaps a need for early intervention.
Okay.
Let's maybe break each of those down.
All right, age. That seems like a simple starting point, but I did notice some variations in the handbook, especially related to, when the NDIS was first rolled out. Can you tell us a bit more about those age requirements?
Yeah, what's interesting here is how the age rules actually differed as the NDIS was introduced across the country. It wasn't like a single switch flip for everyone all at once.
Right.
For instance, if you were applying before July 1st, 2014, the general rule was being under 6 on July 1st, 2013. Simple
Yeah.
enough. But then South Australia had its own starting point,
Hmm.
focusing on those under 14 on July 1st, 2014.
Okay.
Tasmania's initial phase was even more specific. It targeted people aged 15 to 24 when they applied, and they had to be under 25 on July 1st, 2013.
Wow.
Then, for later applications, the age generally shifted. First to under 14 on July 1st, 2014, and then finally under 15 on the actual date you applied, if that happened on or after July 1st, 2015.
Wow, okay, that's a lot of specific dates and ages to keep track of. It really sounds like the initial rollout was a carefully staged process.
It definitely was. Phased.
The handbook also mentions potential difficulties in determining someone's age if they were born outside Australia. What sort of challenges could that create?
Yeah, this raises a really important point about documentation, doesn't it? If someone was born overseas, particularly if they came to Australia later in life, maybe didn't have a birth certificate handy,
Right.
providing official proof of their exact age at a specific point in the past can be tricky if those reliable records just aren't readily available.
Mm.
The agency would then need to rely on whatever documentation can be provided, which could, sometimes lead to delays or just add complexity to their application.
Right, okay, that makes sense. Documentation can be a hurdle. Now, let's talk about where you need to live the residence requirements. It's not just about being physically in Australia, is it?
Not quite, no. The main requirement is that you need to be residing in Australia and be one of the following: an Australian citizen, someone holding a permanent visa, or what's called a protected special category visa holder.
Okay, and that protected SCV holder.
That generally refers to eligible New Zealand citizens who've been living in Australia for a certain period. But yeah, residing in Australia isn't just about your physical location at one point in time. It looks at the bigger picture of your life here.
Okay, so what kind of things are considered when they're determining if someone is truly, residing in Australia?
Well, the handbook highlights several factors that help paint that picture. Things like the type of accommodation you have here, your family connections in Australia,
Right.
how much you work, or if you have business or financial ties to the country, any assets you might own here, and also how often and for how long you travel outside of Australia.
Hmm.
Crucially, It also considers whether you actually intend to stay in Australia permanently.
Hmm.
It's really about showing that Australia is your home base.
So it's about having your life established here, not just like visiting long term.
Exactly.
And just like with the age rules, I noticed there were specific residence rules when the NDIS was first launching in certain areas that phased rollout again.
Exactly, yeah. Because the NDIS was rolled out area by area, the rules specify that to meet the initial residence requirement in those early stages, you generally had to be living in one of the designated launch areas on a specific date.
Hmm.
Usually July 1st, 2013 for most of the first sites, and July 1st, 2014 for the ACT. These initial launch areas included parts of South Australia, Tasmania, Victoria, like Geelong and Colac Otway in New South Wales, around Newcastle and Lake Macquarie.
Right. And the handbook talks about a qualifying residence requirement and then an ongoing residence requirement. What's the difference there?
Good question. The qualifying residence requirement was specifically linked to being in those launch areas on those initial dates. It was about establishing that connection to a region participating in the NDIS right from the start.
Okay.
The ongoing residence requirement, on the other hand, means that even after you become a participant, you need to continue living in Australia and maintain your status as a citizen, permanent visa holder, or protected SEV holder.
I see.
And if you no longer meet these ongoing residency requirements, your participation in the NDIS could actually be revoked.
That's a really important thing to understand, yeah. Your circumstances can change. And there was also a condition mentioned about the dominant purpose for living in a launch area. That sounds a bit unusual.
Yeah, that's a fascinating little detail from the launch phase. If someone actually started living in a launch area after those initial key dates in 2013 or 2014,
Mm-hmm.
they also generally needed to show that their main reason for moving there wasn't just to access NDIS supports that were already being provided under existing systems, things like, standard education, employment help, or general health care.
Oh,
They usually also had to demonstrate exceptional circumstances, like facing significant financial or personal hardship if they couldn't get onto the NDIS.
right.
This condition was likely put in place to sort of manage the initial demand, ensure the NDIS wasn't immediately overwhelmed by people moving to those specific areas solely to access the scheme right at the start.
Okay, yeah, that makes sense in the context of a phased introduction, managing the flow. All right, so we've covered age and residence. The third core criterion is disability or the need for early intervention. This feels like it could have the most depth to it. We should probably discuss this extensively.
It certainly has more layers, yeah. The Act outlines two main ways to meet this criterion. The first is by meeting the definition of disability itself, and the second is through the need for early intervention support, usually for children.
Right.
Let's start by really delving into what constitutes the disability requirement. There are several specific aspects that need to be satisfied here.
Okay, lay it on us. What exactly defines disability for NDIS purposes?
Okay, so firstly, there needs to be an impairment that is likely to be permanent. This can be an intellectual, cognitive, neurological, sensory, physical, or even a psychiatric impairment.
Hmm.
Secondly, this permanent impairment must result in a significant reduction, substantially reduced functional capacity, is the term they use, in your ability to do everyday things in one or more of 6 key areas.
6 areas, okay.
How you communicate, how you interact socially, how you learn, how you move around. So mobility, how you look after yourself, self-care, or how you manage your own life, self-management.
Right.
Thirdly, the impairment needs to actually affect your ability to participate in social or economic life. Get involved in the community, hold down a job.
Makes sense.
And finally, it must be likely that you will require NDIS support for your whole life.
That's a pretty detailed set of criteria. The
Yes.
handbook also clarifies what permanent impairment means in this context, doesn't it? It's not always straightforward.
Yes, it does.
Yeah.
Rule 5.4 clarifies this. An impairment is considered permanent if there aren't any known, available, and appropriate treatments, whether they're clinical, medical, or something else, and importantly, based on evidence that would likely remedy the impairment.
Remedy it. Okay.
Yeah. And importantly, the handbook points out that even if the severity of the impairment fluctuates, goes up and down, or if there's a chance the impact of the impairment might improve over time, that doesn't automatically mean it's not considered permanent. The key question is whether the underlying impairment itself can be fixed or cured with current treatments.
Okay, that's a really important distinction. And the NDIS website has a list, right, of conditions that generally meet this impairment and permanence criteria, although people might still need to show that significant reduction in functional capacity.
That's right. It's often referred to as List A.
Can you give us a few examples from that list just to illustrate?
Absolutely. The list includes conditions like Alzheimer's disease, autism spectrum disorder, cerebral palsy, Down syndrome, epilepsy, intellectual disability, multiple sclerosis, muscular dystrophy, paralysis, stroke, amongst many others.
Right.
It's a pretty broad range, which highlights the NDIS's aim to support people with many different kinds of long-term significant impairments.
Okay, that gives us a much clearer picture of the main disability requirement. Now, what about the early intervention pathway? How does someone qualify through that route?
Okay, so the early intervention pathway is specifically for individuals, often young children, who might not yet meet all of the criteria for a permanent disability under that first pathway,
Hmm.
but they have an impairment or perhaps a developmental delay where providing support early on is likely to make a really positive difference down the track. There are basically three things that need to be true here.
Okay, what are they?
First, the person must have an impairment that is likely to be permanent, using that same definition we just talked about, or if it's a child under 7, they must have a developmental delay.
Okay, impairment likely to be permanent or developmental delay for young kids. What else?
Secondly, the NDIS CEO needs to be satisfied that providing early intervention support is likely to lead to one or more positive outcomes.
Such as?
Well, this could mean reducing or lessening the impact of the impairment on their ability to function in those same 6 areas we mentioned: communication, social interaction, learning, mobility, self-care, or self-management.
Right.
It could also mean preventing that functional capacity from getting worse over time, or perhaps actually improving it. Or even just making the informal supports they have, like help from family, more sustainable in the long run.
So it's really about stepping in early, trying to mitigate future needs, and helping a child reach their full potential.
Exactly. That's the core idea.
And is there also a list of conditions, like a list B, that often meet the early intervention criteria?
Yes, similar to the disability list, there's a list for conditions where early intervention is commonly beneficial. This includes things like Angelman syndrome, Asperger's, autistic disorder, cerebral palsy again, Down syndrome again, Fragile X syndrome, and significant hearing or vision loss, among others.
Okay.
But again, it's just a guide. The key question is always whether providing that early intervention is likely to lead to those positive changes we just discussed.
This is all incredibly detailed, and it really highlights the depth of consideration that goes into determining eligibility. Now, the handbook also mentions an alternative way someone might meet the access criteria, even if they don't quite tick all the boxes for age or disability early intervention. This sounds like it could be important for some people.
It is, yeah. It acts as a kind of safety net in specific situations.
Yeah.
Under Rule 7.1, the CEO actually has the discretion to approve access if a person doesn't quite meet the standard age or disability yearly intervention criteria, but only if several very specific conditions are met.
Okay, what sort of conditions?
This usually applies to individuals who have a permanent and significant disability that resulted from a condition they were born with, a congenital condition, or maybe an injury that happened before they turned 6 years old.
Right, very early onset.
Yeah. And the condition also typically needs to be linked to an intellectual disability, autism spectrum disorder, or perhaps a neurological condition that severely affects their ability to adapt and function in daily life, what they call adaptive functioning.
And are there other things the CEO takes into account in these sort of alternative cases?
Yes. The CEO also needs to be satisfied about a few other things, like whether the person has sought or received any compensation related to their disability, what the financial situation of the person and their family looks like, and the potential impact that requiring them to take certain actions, like maybe pursuing a complex compensation claim, would have on them and their family.
I see.
So this alternative pathway really recognizes that there might be individuals with very significant needs who might just fall slightly outside the standard criteria, but still clearly require and would really benefit from NDIS support.
This thorough discussion on eligibility has been incredibly insightful. I feel like we've really covered the breadth of it. It's clear there are many factors and specific rules involved in determining who can access the NDIS. When we come back, we'll shift our focus to what happens once someone is eligible. We'll be exploring participants' plans, the supports they can receive, and how that funding is managed. This is definitely a lot to take in, but it's so foundational to understanding the NDIS.
Absolutely. It sets the stage for everything else.
Welcome back to our deep dive into the National Disability Insurance Scheme. We've just spent a good chunk of time unpacking the often complex eligibility criteria. Now we're going to move on to what happens once someone is deemed eligible. The development and implementation of their participant plan, the supports they can access, and how the funding side of things works.
Yeah, this is where the NDIS really starts to become personalized for each individual participant. The handbook dedicates a significant section to participants' plans, supports, and funding, really emphasizing the individual nature of the scheme.
So, the first step after being found eligible is creating this participant's plan. What exactly does that involve? What's in it?
Okay, so according to the Act, a participant's plan has two main parts. The first part is the participant statement of goals and aspirations.
Goals and aspirations, okay?
This is very much driven by the participant themselves or their representative, if
Yeah.
needed, and it outlines what they want to achieve in their life, their objectives, their hopes for the future. It also includes basic information about where they live and their personal circumstances.
It sounds very much focused on the individual, which is good. And what about the second part of the plan?
The second part is the statement of supports. This is where it details the specific, reasonable, and necessary supports that will be funded or provided by the NDIS to help the participant work towards those goals they outlined in the first part.
Okay. And are these supports just like a standard list they pick from, or can they be really tailored to the individual specific needs?
No, they're definitely intended to be highly individualized. The handbook even mentions that in specific situations, a particular provider or even a specific way of delivering a support can be written into the plan.
No, interesting.
Yeah, if the CEO believes it's required because of the participant's disability, maybe they need highly specialized evidence-based support, or perhaps a particular delivery method just works much better for them.
That makes sense. You wouldn't want a generic one-size-fits-all approach for something so personal. Now, when it comes to actually funding these supports, are there specific rules or limits? How does that work?
Absolutely. Any support that is funded through an NDIS plan must meet the criteria of being reasonable and necessary, according to the NDIS rules.
Right, there's that term again.
Yeah, it's key.
Mm.
Additionally, there are certain types of supports that the NDIS specifically does not fund, which we should probably touch on. And the CEO has to consider 8 specific factors, which are detailed in the rules when deciding what actually qualifies as reasonable and necessary.
Okay, reasonable and necessary. We've heard that a few times now. What's the core idea behind it? What does it really mean in practice?
Well, the fundamental principle is that the supports funded should help the participant pursue their goals, become as independent as possible, and be actively involved in their community and, where possible, in employment.
Mm-hmm.
They need to be both sensible in terms of cost and also essential for achieving those positive outcomes for the person.
And what are the specific things the CEO considers when deciding if a support meets that threshold? Those 8 factors you mentioned.
Okay, the handbook breaks it down into several key criteria. First, the support must be directly related to the participant's disability.
Yeah.
Seems obvious, but important.
Yeah.
Second, it must be necessary to help them achieve their goals and participate in their daily life. Third, it needs to be effective and provide benefit. And here they look at current best practices and available evidence.
Okay, evidence-based.
Exactly. Fourth is value for money, looking at whether the cost is comparable to other options, the long-term benefits, and if it has the potential to reduce future support costs.
Right.
And fifth, the funding of the support must fall under the NDIS's responsibilities, meaning it's not something that should realistically be covered by other mainstream services like the health system or education.
That value for money point seems really important, especially for ensuring the NDIS is sustainable in the long run.
Yeah.
What are some of the things considered under that specific criterion?
Yeah, it involves quite a bit. Comparing the cost of the proposed support to other supports that could achieve a similar outcome,
Yeah.
looking at the long-term benefits and potential savings down the track,
Mm-hmm.
and considering whether it's more cost-effective, say, to buy or lease a piece of equipment. It also takes into account advancements in technology. Maybe a newer device costs more upfront but saves money later.
Mm-hmm.
And they look at whether the cost of the support is similar to what others pay for the same thing in the participant's local area.
Ultimately, it's about whether the support will increase the participants' independence and potentially reduce their reliance on other, perhaps more costly supports over time.
Okay, that makes sense. A long-term view. So there are definitely guidelines to ensure responsible use of funds. You mentioned some supports are generally funded by the NDIS and others are generally not. Can you give us some examples of each to make that clear?
Sure. Generally, the NDIS will fund supports that directly relate to a person's ongoing functional impairment and help them with everyday activities, being part of their community, accessing education, and finding or keeping a job.
Okay.
This can include things like personal care assistance, various therapies, physio, OT, speech aids, and equipment tailored to their needs, and supports for children that go beyond what's typically needed for a child of their age. It also includes supports that help carers continue in their caring role.
Right. And what about the kinds of supports that are typically not funded by the NDIS? Where does the line get drawn? Okay, so the NDIS generally won't fund things like getting a clinical diagnosis that's usually health, or the ongoing treatment of health conditions.
Yeah.
Standard services from doctors, most allied health professionals, unless it's directly related to their disability support needs that can't be met by the health system, dentists or hospitals. Also, palliative care or post-acute rehabilitation, those are typically health responsibilities.
Okay.
It also typically doesn't cover early childhood education and care needs that are considered part of mainstream services, statutory child protection services, general parenting programs that aren't disability-specific,
Right.
sports specifically for work-related things like recruitment or standard workplace adjustments. Those usually fall under employment services,
Hmm.
or modifications to private vehicles, generally.
Okay.
And finally, it doesn't usually cover things like making public transport more accessible in general or funding transport infrastructure. These are usually seen as the responsibility of other mainstream systems or broader government infrastructure programs.
That distinction really helps clarify where the NDIS's responsibility begins and ends. It's not meant to cover everything. Now, once a plan is in place and funding is allocated, how does a participant actually manage that funding? Do they get a say?
Yes, definitely.
No.
Participants have a say in how their NDIS plan funding is managed. They can choose to manage the funds themselves, self-management. They can have a registered plan management provider handle the financial side for them, or they can have the agency itself manage the funds, which is called agency managed.
Right.
The CEO is required to consider the participants' preferences as much as is reasonable when deciding who will manage the funds.
And what happens if a participant maybe doesn't have the capacity to manage their own funds, if self-management isn't feasible for them?
Yeah, the Act acknowledges that. Some participants may not have the ability to manage their funding either fully or partially. In those situations, the plan must specify that the funding will be managed either by a registered plan management provider chosen by the agency or by the agency directly. And this is where the role of plan nominees becomes really important, because someone can be appointed to manage the funding on behalf of a participant who lacks that capacity. We should definitely get into nominees in more detail a bit later.
Yes, absolutely. Okay, that covers the initial plan and how funding is managed, but people's lives change, right? Their support needs might evolve. How often are these plans reviewed?
Good point. The CEO has the authority to review a participant's plan. While the Act doesn't set out a rigid, fixed time frame for routine reviews for everyone, they can be initiated for various reasons, like a significant change in the participant's circumstances, or maybe their goals have shifted.
Right.
The CEO is required to start the process of a review within 14 days of deciding to do one, and then complete it as soon as reasonably possible. Importantly, participants also have the right to request a review of certain decisions made by the CEO that relate to their plan.
Okay. What if a participant needs to go overseas temporarily? Does that impact their NDIS plan, say for a holiday or work?
Yes, the Act includes what's called a grace period for temporary absences from Australia. Generally, this is 6 weeks.
6 weeks. Okay.
During this time, the participant's plan usually continues as normal. The CEO does have the discretion to extend this grace period if they believe it's appropriate, based on specific criteria in the rules, like if the absence is for an approved exchange program, maybe temporary overseas employment or involvement in the reserve forces. However, if a participant is outside Australia for longer than the grace period, their plan is generally put on hold, suspended until they return and are residing in Australia again.
So the plan isn't canceled entirely, just sort of paused while they're away longer term?
Exactly. Suspended is the key word.
And what if a participant is required to pursue, say, a compensation claim related to their disability but doesn't take action? Can that affect their plan?
Yes, that can also lead to a suspension of the supports outlined in their plan. If the CEO issues a written notice requiring a participant to take specific steps regarding a compensation claim they might be entitled to, maybe from an accident that caused their disability, and they fail to do so,
Right.
the funding under their plan can be suspended until they take the required action. It's important to note that during any suspension period, NDIS payments are stopped, and the CEO isn't obligated to provide or fund other supports, although they can choose to do so in some cases.
Okay.
Also, a participant can't apply for a plan review while their supports are suspended. This really highlights the responsibilities that can come with being an NDIS participant in certain circumstances involving potential compensation.
This is all really important information to understand the sort of ongoing nature of NDIS support and the rules around it. Finally, for this section, the handbook discusses needs assessments. How does the agency actually determine a participant's needs in the first place in order to create their plan?
Right, the assessment process. The CEO is required to use specific methods and tools, which are detailed in the rules and operational guidelines, to assess a participant's individual needs. There are 4 key things the CEO must do during this assessment process.
4 key things, okay?
1, identify the participant's goals, aspirations, abilities, strengths, their current situation, and their broader context. 2, assess any limitations, restrictions, or support needs that arise specifically from their disability. 3, evaluate any safeguards and risks that are relevant to them.
Yeah.
And 4, connect those identified support needs directly back to the participant's stated goals and aspirations from Part 1 of their plan.
And are these assessment tools standardized? Is it the same tool for everyone?
Not necessarily. The CEO has the flexibility to specify different assessment tools for adults and children, and even tools that are specifically designed for different types of impairments.
Hmm.
Importantly, any assessment tool used must be aligned with the World Health Organization's International Classification of Functioning, Disability, and Health, the ICF.
Okay.
This helps ensure a comprehensive, internationally recognized understanding of the person's needs in relation to their participation in society. The handbook really emphasizes that these assessments must be fair and transparent, using appropriate tools that are applied correctly by trained assessors.
This has been another incredibly detailed discussion covering the critical aspects of participant plans, the range of supports available, and how the funding operates. When we return, we'll be looking at the important role of nominees in the NDIS, who they are, how they get appointed, and what their responsibilities entail.
Yep, a really important piece of the puzzle.
Welcome back to the deep dive. We've explored eligibility and participant plans quite extensively, and now we're turning our attention to a really important component of the NDIS framework, nominees. These are individuals who can be appointed to act on behalf of a participant in certain aspects of their involvement with the scheme.
That's right. The CEO has the authority to appoint both plan nominees, who are primarily responsible for managing the financial aspects of a participant's plan, and correspondence nominees, who receive official communications from the agency and can act on certain requirements on the participant's behalf. It's also worth noting that the same person can be appointed to hold both roles for a single participant if that's appropriate.
So what's the fundamental purpose of having nominees in the first place? Why might a participant actually need one?
Well, nominees are often appointed to provide support to participants who might face challenges in independently managing their NDIS plan, or perhaps communicating effectively with the agency.
Right.
This could be due to their disability, maybe their age, or other circumstances that affect their capacity to make decisions, or simply handle the administrative tasks that come with being part of the NDIS.
And who is eligible to be appointed as a nominee? Is there a specific process the agency follows for this?
The CEO can appoint a nominee either at the participant's own request, or sometimes on the CEO's own initiative if they see a need. The handbook emphasizes that if a participant already has a legally appointed decision-maker, like, say, a guardian appointed by a court, or someone they have personally appointed with similar legal powers through an enduring power of attorney, for example, the CEO is required to consider appointing that same person as their NDIS nominee. The CEO also needs to assess whether the potential nominee is actually willing and has the capacity to effectively carry out the duties that come with being a nominee.
Are there any restrictions on who can be appointed or specific criteria they need to meet?
Yes, the rules can specify who is not eligible to be a nominee, and they also outline criteria that the CEO must take into account when making an appointment. For example, if an organization or a body corporate is being considered as a nominee.
The trustee company.
Exactly, yeah. The CEO will typically require them to identify a specific officer or employee within that organization who will be directly responsible for performing the nominee functions for that particular participant. So there's a named contact.
Right, accountability. Okay, once someone is appointed as a correspondence nominee, what are their main responsibilities in that role?
Okay, so if the agency sends a notice to a correspondence nominee, it is legally considered to have been given directly to the participant on the exact same day.
Oh, okay. Legally equivalent.
Yeah. The correspondence nominee also has the authority to provide information or documentation to the CEO on the participant's behalf and can fulfill other requirements under the Act for them. However, and this is really important to understand, if the correspondence nominee fails to meet a requirement,
Hmm.
the participant themselves is considered to have failed to comply. This really highlights the significant responsibility that comes with being a correspondence nominee. You're acting legally for that person in relation to NDIS communication.
Wow, okay. That's a serious responsibility. And what about plan nominees? Their responsibilities would primarily focus on the financial aspects of the NDIS plan, I assume.
Precisely. Plan nominees are responsible for managing the NDIS funds that are allocated in the participant's plan. The CEO also has the power to issue notices directly to plan nominees, requiring them to provide detailed statements about how the NDIS funds that have been paid to them on behalf of the participant have actually been used.
Right.
This ensures financial accountability and transparency in the management of those NDIS funds when a nominee is involved.
It sounds like nominees, whether correspondents or plan nominees, take on quite significant responsibilities. Can their appointments ever be changed or canceled once they're in place, if circumstances change, for instance?
Yes, absolutely. Nominee appointments can be both suspended and ultimately canceled. If a participant who initially requested the appointment of a nominee later asks the CEO to cancel it, the CEO is legally obligated to do so as soon as reasonably practicable. And even if the nominee was initially appointed on the CEO's own initiative, the CEO still has the authority to cancel that appointment if the participant requests it. In those cases, the CEO has 14 days to make a decision and must provide written notification of that decision to both the participant and the nominee involved.
Are there other circumstances under which a nominee's appointment might be suspended or canceled by the CEO, perhaps not at the participant's request?
Yes, there are. The CEO has the power to suspend or cancel a nominee's appointment if um, the nominee's ability to act effectively becomes compromised in some way, or if the CEO has a reasonable belief that the nominee has caused or is actually likely to cause physical, mental, or even financial harm to the participant.
Right, safeguarding.
Exactly. In all situations where an appointment is canceled, the CEO is required to provide written notification outlining the reasons for the cancellation to both the nominee and the participant.
This provides a really helpful overview of the role and the responsibilities and the safeguards associated with being an NDIS nominee. When we come back, we'll be shifting our focus to discuss the crucial topic of the privacy of information within the NDIS framework.
Yeah, another really critical area.
Welcome back to our deep dive. We've been exploring the various elements of the NDIS, and now we're going to discuss a really fundamental aspect, the privacy of information. Given the very personal nature of the information that is collected and used by the NDIS, strong measures to protect that privacy are absolutely essential, wouldn't you say?
Oh, entirely correct. You can't overstate its importance. The Handbook includes a dedicated section on privacy, emphasizing that the Act and its associated rules have specific measures in place to safeguard the personal information of participants and really anyone else involved with the NDIS.
So, in the context of the NDIS, what exactly is considered protected information? How broad is that definition?
The Act defines protected information quite broadly. It's essentially any information about an individual that is currently held or was previously held in the official records of the National Disability Insurance Agency.
Okay.
This encompasses a really wide range of personal details and information directly related to a person's disability, their individual NDIS plan, and the specific supports they are receiving or have received in the past. So it's quite extensive.
And what are the rules that govern how this protected information can be recorded, disclosed, or used by the agency? They can't just share it freely, obviously.
No, definitely not. The Act establishes specific conditions under which protected information can be handled. Generally speaking, it's permitted if it's directly related to achieving the purposes of the Act itself.
Mm-hmm.
If the information concerns has given their explicit consent for it to be used or shared in a particular way, or if the disclosure or use is specifically required or authorized by another law. The CEO of the agency is also permitted to use this information internally for legitimate purposes like research, statistical analysis, and the development of NDIS policies, as well as to comply with any formal request for information made by the CEO themselves under their inquiry powers.
It sounds like getting consent is a really important principle here. Are there any situations where the CEO might be able to disclose information even without someone's direct consent?
Yes, there are certain limited exceptions where that can happen. The CEO can disclose protected information if they issue a formal certificate, stating that it is necessary in the public interest to do so, either in a particular case or maybe for a specific category of cases.
Okay, public interest.
Yeah. They can also disclose information directly to the participant themselves, obviously, or to their appointed nominee, or to a formally appointed child's representative. Additionally, there are some very specific circumstances outlined in the legislation where disclosure is permitted, such as for providing necessary briefings to the relevant government minister. In cases involving missing or deceased persons, or if the disclosure is necessary to correct a clear mistake of fact that's on the record.
The handbook also makes a point of stating that the unauthorized disclosure or misuse of protected information is actually a legal offense. That really underscores the seriousness of these privacy regulations within the NDIS.
Absolutely. There are legal penalties in place, including potential imprisonment, to act as a very strong deterrent against any improper handling of this sensitive personal information. It really highlights the importance that the legislation places on ensuring the privacy of individuals who are interacting with the NDIS.
And how does this NDIS privacy framework interact with other existing privacy laws, like, say, the Commonwealth's Freedom of Information Act or state privacy laws?
Yeah, good question. Section 69 of the NDIS Act specifically clarifies that it does not in any way alter the operation of the Freedom of Information Act at the Commonwealth level. So FOI requests can still be made. Interestingly, while there isn't a broad statement covering all other Commonwealth or state and territory privacy legislation, the NDIS rules do specifically list a number of key state and territory privacy acts, like those in Victoria, NSW, ACT, etc., and clarify that the NDIS Act's provisions regarding the disclosure of information to the agency do not change the effect of those listed state and territory acts.
So if a state law protects certain info.
Exactly. It suggests a deliberate effort to ensure that existing privacy protections at those state and territory levels are generally maintained when individuals or other bodies provide information to the NDIS.
That's really good to know. It indicates an effort to sort of integrate the NDIS privacy rules with the broader legal landscape around protecting personal information. When we come back after this short break, we'll be looking at another very important aspect of the NDIS, the process for reviewing decisions. What happens if a participant or a potential participant disagrees with the decision that the agency has made?
Yep, the appeals process. Crucial stuff.
Welcome back to the deep dive. We've just finished discussing the important topic of privacy within the NDIS, and now we're going to move on to what happens if a participant or someone applying to the NDIS disagrees with a decision made by the CEO or the agency. The Act provides clear pathways for having these decisions reviewed, which is vital.
It's a really critical part of ensuring fairness and accountability within the entire scheme. Absolutely. Section 99 of the Act specifically lists the types of decisions made by the NDIS CEO that are officially classified as reviewable decisions.
And what kind of decisions are we talking about here? Can you give us a few examples of the types of decisions that can typically be reviewed?
Well, the handbook doesn't provide an exhaustive list right here, but generally these include really fundamental decisions like whether an individual meets the initial AFIS criteria to become a participant in the first place. That's a big one.
Yeah, definitely.
They also include decisions about the specific content of a participant's plan, for example. Decisions about the types and levels of supports that will be funded. Very common area for review. Additionally, decisions related to the appointment or the cancellation of nominees are also typically reviewable. The fact that these key areas are specifically designated as reviewable really underscores their significance in a person's overall journey with the NDIS.
So if someone wants to challenge one of these reviewable decisions, what's the very first step they need to take? Where do they start?
Okay, the initial step is to request an internal review within the agency itself. If a person is directly impacted by a reviewable decision, they have the right to ask the CEO to conduct an internal review of that specific decision.
Right.
This request usually needs to be submitted within 3 months of the person receiving written notification of the original decision they disagree with. The review is then carried out by a designated reviewer within the NDIS agency, someone who wasn't involved in the original decision.
And what exactly is the reviewer expected to do during this internal review process? What's their job?
The reviewer's role is essentially to take a fresh, independent look at the original decision that was made. They're required to, as quickly as is reasonably possible, make a new decision.
A completely new decision.
Well, the new decision could be to uphold or confirm the original decision, say it was correct. Or they could decide to change or vary it in some way. or even to completely set aside the original decision and make an entirely new one in its place.
Okay.
The handbook emphasizes that written notification of the outcome of this internal review must be provided to the person who requested it, explaining the reviewer's decision and the reasons for it.
If someone goes through this internal review process and they're still not satisfied with the outcome, maybe the reviewer confirmed the original decision they disagreed with. Are there any further avenues for appeal or review after that?
Yes, definitely. Section 103 of the Act provides that decisions made by the internal reviewer can then be taken to an external review body. This is the Administrative Appeals Tribunal, or AAT.
The AAT.
This is an independent body that has the authority to conduct a broader, more formal, and more in-depth review of the case, looking at all the evidence again. It's important to note that under the AT's own act, formal notice of the application for review must also be given to anyone else whose interests are likely to be affected by the AT's decision.
And if the AT makes a decision on the matter, is that generally considered the final say in the process, or can it go further still?
Generally, the ADT's decision is very significant, and for many people, it is the final step. However, there is still a possibility of appealing the AT's decision to the Federal Court of Australia.
Okay.
But it's important to understand that appeals to the federal court are typically limited to challenging the AT's decision only on specific questions of law.
Not the facts.
Generally not.
Yeah.
It's about whether the AT made a legal error in how they interpreted the NDIS legislation, for example. It's usually not an opportunity to simply re-argue the factual details of the case that were already presented to and considered by the AT.
Right, a legal technicality appeal. The handbook also highlights the importance of providing clear notice when a reviewable decision is initially made by the agency. What specific information must be included in that notice?
Yes, that's crucial for procedural fairness. When the CEO makes a decision that is classified as reviewable, they are legally required to provide written notice of that decision to every person who is directly affected by it. This notice must clearly state that the person has the right to request an internal review of the decision by the CEO under Section 103 of the Act. The notice must also clearly specify the time frame within which that request for an internal review must be made, which, as we mentioned, is typically within 3 months of receiving the notice of the original decision.
Okay. What happens if someone starts the internal review process but then changes their mind? Maybe they resolve the issue another way or just decide not to pursue it. Can they withdraw their request?
Yes, they can. A person who has submitted a request for an internal review has the right to withdraw that request at any point in the process before the reviewer makes their decision.
How do they do that?
It can be done by sending or delivering a written notice of withdrawal directly to the CEO. Or, alternatively, the person can also contact the CEO orally, in person, by telephone, or maybe through other means of communication to formally withdraw their request.
Right.
If the withdrawal was communicated orally, the person within the agency receiving that withdrawal is responsible for making a written record of the details, including the date it was withdrawn.
Now, review processes and appeals, especially to the AAT or federal court, can sometimes involve legal costs. Does the NDIS provide any funding to help participants cover these costs if they choose to seek a review or get legal advice?
This is a really important practical consideration for people thinking about a review. Section 200A of the Act specifically states that the National Disability Insurance Agency is neither required nor permitted to provide funding for legal assistance to prospective participants or current participants in relation to the review of decisions made under the Act.
So no funding for lawyers from the NDIS?
That's right. It means that individuals who choose to seek legal representation during an internal review or a subsequent appeal to the AAT or the federal court will generally need to bear those legal costs themselves or seek assistance through other channels like legal aid if they qualify.
Finally, the handbook mentions a specific practice direction issued by the AAT that applies just to NDIS reviews. What does that entail for someone going through that AAT process?
Yes, the AAT has indeed published a specific practice direction designed to guide the review process for NDIS decisions. It sets out how the ADT handles these cases.
Okay.
This practice direction outlines the various steps involved in an NDIS review at the AAT. These steps often include initial case conferences, which are designed to sort of explore potential areas of agreement between the applicant and the agency and to plan how the application will proceed. Conciliation is also often offered as a form of alternative dispute resolution, trying to reach an agreement without needing a formal hearing. If a resolution can't be reached that way, the practice direction also outlines the procedures for a formal hearing before the tribunal member. It also covers important practical aspects, like the exchange of relevant documents between the parties, often referred to as T documents, and the possibility of requesting an expedited or fast-track hearing in certain urgent circumstances.
Okay.
This practice direction is a really valuable resource for anyone or their advocate who finds themselves needing to navigate the AAT review process for an NDIS decision. It tells you what to expect.
This has been a really helpful and detailed overview of the process for reviewing decisions within the NDIS. It's definitely good to know that there are mechanisms in place, both internal and external, for participants and applicants to challenge decisions they believe are not correct or fair. When we return after the break, we'll be focusing on how the NDIS specifically addresses the needs and involvement of children within the scheme.
The very important cohort, yes.
Welcome back to the deep dive. We've been exploring various facets of the NDIS, and now the focus on a particularly important group of participants within the scheme: children. As the handbook highlights, children make up a significant proportion of NDIS participants, especially when you consider the initial age focus of the rollout in the early launch sites.
Absolutely. And recognizing the unique developmental stages and specific needs of children with disability is absolutely paramount. The Act itself, along with the specific National Disability Insurance Scheme, Children Rules 2013, outlines specific considerations for how the scheme is to be administered in relation to children.
What are some of the overarching principles that guide the NDIS when it comes to its involvement with children? What's the main focus?
Well, the single most important principle it's stated right up front is that the best interests of the child must always be the paramount consideration in any decision-making process related to a child under the NDIS.
Paramount. Okay.
Yet this fundamental principle overrides all other considerations. Alongside this, other key guiding principles include the critical need to protect the child from any form of harm, to actively promote their overall development, and also to strengthen and support their relationships with others who are important in their lives, obviously parents, but also other family members and their broader social network.
When you're dealing with children and the NDIS, the concept of parental responsibility seems particularly relevant. How's that defined within the specific context of the NDIS? Who has it?
Good question. The NDIS Act actually adopts its definition of parental responsibility directly from the Commonwealth Family Law Act 1975.
Ah, okay. Uses existing law.
Yeah. Generally speaking, a person has parental responsibility for a child if they are the child's biological or adoptive parent, and they haven't legally ceased to have that responsibility under the Family Law Act.
Right.
This definition also extends to individuals who have a current parenting order from the family court stating that the child lives with them or spends significant time with them, and that they have responsibility for the child's care, welfare, and overall development.
Okay.
And importantly, if someone has been appointed as the legal guardian of a child under a relevant Commonwealth, state, or territory law, perhaps through child protection processes, they also generally hold parental responsibility for the purposes of the NDIS, unless the CEO of the agency makes a specific determination otherwise.
What happens if there is more than one person who would potentially have parental responsibility for a particular child? Maybe separated parents, for example.
Yeah.
How does the NDIS determine who to work with?
Right, that can happen. In situations where there are multiple individuals who would ordinarily have parental responsibility for a child, the CEO of the NDIS agency has the discretion to make a formal determination specifying that one or perhaps more of those individuals will be recognized as having parental responsibility for the specific purposes of the NDIS.
Okay, they can choose who acts.
Yeah, or specify both need to agree, potentially.
Mm-hmm.
There are also specific rules that outline the process the CEO must follow when making such a determination, particularly in circumstances where the CEO believes that it may not be appropriate for the person or people who would ordinarily have parental responsibility to be acting on the child's behalf in the context of the NDIS.
Right.
For instance, maybe if there are safety concerns,
Right.
and if a state or territory government minister holds guardianship of the child, the CEO is generally required to obtain their written agreement before making a determination about parental responsibility for NDIS purposes.
Okay. Once parental responsibility has been established for a child in the NDIS context, what are the specific duties and obligations of those individuals, the parents or guardians, in relation to the child's participation in the NDIS?
Section 761 of the NDIS Act places a clear duty on the person or people with parental responsibility. They must actively seek to understand the wishes of the child and always act in what they reasonably believe to be the child's best interests in all matters related to the NDIS.
Reasonably believe. Okay.
Yeah, the Act recognizes it's not always possible to know with absolute certainty what a child wants or what is definitively in their best interest, especially for very young children or those with complex communication needs. So it provides a degree of protection by stating that this duty is not considered to have been breached if the person had a reasonable belief that they were acting in accordance with the child's wishes and best interests at the time.
Right.
The NDIS rules also outline further specific duties, including the responsibility to support the child to make their own decisions to the greatest extent possible based on their capacity, and to have due regard for and give appropriate weight to the child's own views and preferences, again, where possible.
The handbook also discusses the possibility of the CEO appointing a child's representative. Under what circumstances might this occur, and what is the role of such a representative?
Right. The CEO has the authority to appoint a child's representative to perform various duties and exercise powers on behalf of the child in specific situations. This might happen where there are significant doubts or uncertainties about who actually holds parental responsibility for the child. Maybe it's unclear. Or if the CEO has formed the view that it is simply not appropriate for the child's parents or legal guardians to be acting on their behalf in relation to the NDIS, maybe due to conflict of interest or capacity issues or safety again.
Okay.
When considering whether to make such an appointment, the CEO is required to take several important factors into account. These include any expressed preferences of the child themselves, if they're able to communicate them, the desirability of preserving the child's existing family relationships and informal support networks, who is assessed as being best placed to effectively carry out the duties required under the NDIS Act and rules, any existing arrangements that are already in place between a potential representative and the child who currently has day-to-day responsibility for the child's care, and crucially, the potential representative's demonstrated ability to work collaboratively with other relevant people and organizations involved in the child's life.
So a child's representative essentially steps in to act in place of someone with parental responsibility in these specific circumstances, ensuring that the child's needs and best interests are still being fully addressed within the NDIS framework.
Exactly. It's a safeguard mechanism.
And can these determinations about who has parental responsibility or the appointment of a child's representative, can they be reviewed or changed at a later date if circumstances evolve?
Yes, they can. The CEO does have the authority to revoke a previous determination of parental responsibility or to cancel the appointment of a child's representative if the relevant circumstances change significantly or if it is subsequently deemed necessary and appropriate to do so in the child's best interests.
This really clarifies how the NDIS carefully navigates the complexities of involving children in the scheme, always prioritizing their best interests and ensuring they have appropriate representation and support tailored to their unique needs and developmental stages. When we return for our final segment today, we'll be discussing the various circumstances under which a person might actually cease to be participant in the NDIS.
Right. How participation can end.
Welcome back to the final segment of our deep dive into the NDIS. We've covered a huge amount of ground today, from understanding who is eligible to participate and how their plans are developed and discussed extensively, right through to the specific considerations for children within the scheme. Now we're going to look at the other end of the spectrum, the different circumstances under which a person might cease to be a participant in the NDIS.
Yeah, this is an important aspect to understand, as a person's eligibility and circumstances can certainly change over time, or they might simply make a conscious decision that they no longer wish to participate in the scheme. The handbook outlines several key ways in which someone can cease to be an NDIS participant.
What are the primary reasons why someone might no longer be a participant in the NDIS?
Okay, the most common reasons are if they no longer meet the core eligibility criteria that we discussed right at the beginning of our deep dive. That's the requirements around age, where they live, residence, or their disability or need for early intervention support. If one of those fundamental criteria is no longer met, their eligibility ceases.
Right, makes sense.
Additionally, a person has the right to voluntarily withdraw from the NDIS if they decide they no longer wish to be involved.
Okay.
And of course, sadly, a person's participation in the scheme automatically ceases upon their death.
The handbook also mentions that the CEO of the agency has the power to revoke a person's participant status. Under what specific circumstances might this authority be exercised by the agency?
Yes, the CEO has the legal authority to revoke someone's participant status if they become satisfied that the person no longer meets the ongoing residence requirements that we talked about earlier, or if they determine that the person no longer meets either the disability requirements or the early intervention requirements for continued participation. Perhaps their condition has improved significantly due to treatment, for example. Well, that's relatively rare for conditions meeting the permanence criteria.
Right.
If the CEO does decide to revoke a person's participant status, they are legally required to provide written notice to the individual, clearly outlining the reasons for the revocation.
And presumably that decision could be reviewed.
Yes, exactly. As we discussed in our earlier segment on the review of decisions, the former participant would then typically have the right to seek an internal review and potentially an AAT review of that revocation decision if they believe it was made incorrectly.
Okay. What about the process for someone who chooses to voluntarily withdraw from the NDIS? Is that a complicated process?
Generally, no, it seems straightforward. If a person makes a clear and informed decision that they no longer wish to be a participant in the NDIS, they can simply notify the CEO of the National Disability Insurance Agency of their intention to withdraw.
Right.
The Act itself doesn't specify a particular format that this notification must take, but it is generally advisable for the person to do so in writing, just so there's a clear and permanent record of their decision and the date on which it was made.
We also discussed earlier the concept of a temporary suspension of a participant's plan if they are absent from Australia for longer than specified grace period. Does a plan suspension also mean that the person has ceased to be a participant in the NDIS altogether?
No, that's an important distinction. A temporary suspension of a participant's plan due to an extended absence from Australia is not the same as them ceasing to be a participant altogether. As long as the individual continues to meet the fundamental residency requirements of being an Australian resident during their time overseas, even if their absence extends beyond the standard grace period, their NDIS plan is typically suspended, but their underlying status as a participant in the scheme is generally retained.
Right.
The plan will then usually be reactivated upon their return to Australia and their continued residency being confirmed by the agency.
Finally, the handbook makes a brief mention of potential unique issues that might arise related to ceasing participation, specifically during the initial launch phase of the NDIS. What might some of those unique issues have been, do you think?
Yeah, that looking back a bit now, during the initial launch phase, as the NDIS was being rolled out progressively across different regions and gradually replacing existing state and territory-based disability support systems, there were undoubtedly some complexities that arose in relation to people ceasing to participate. For example, if someone moved out of one of the designated launch areas before the NDIS had fully rolled out nationally, that could create issues. Or perhaps if their initial eligibility for the scheme was based on specific launch phase criteria, like those specific age brackets we discussed, that no longer applied once the NDIS became more established nationwide.
Right, transitional complexities.
Exactly. However, the handbook doesn't really delve into specific examples of these launch phase issues in this particular section, which might suggest that these were largely transitional challenges that have become less prevalent as the NDIS has matured and expanded to cover the entire country.
That makes sense. It sounds like the primary reasons for ceasing to be a participant now generally come down to no longer meeting those core eligibility criteria, age, residence, disability yearly intervention, or making a voluntary decision to withdraw from the scheme.
That seems to be the core of it, yes.
Okay. When we return for our very last segment of today's deep dive, we'll be taking a closer look at the significant powers that are held by the Chief Executive Officer, or CEO, of the National Disability Insurance Agency.
Understanding the CEO's role is key.
Welcome back to the final segment of our deep dive into the NDIS. We've covered a vast array of topics today, discussing them extensively, and now we're going to focus our attention on the important powers that are vested in the Chief Executive Officer, or CEO, of the National Disability Insurance Agency.
Yeah, understanding the scope of the CEO's powers is really crucial for grasping how the NDIS is administered on a day-to-day basis and the overall authority of the agency. The Act grants the CEO broad powers to perform their various duties and functions. But it's important to note that they operate subject to any written directions that are provided by the agency's board of directors. Additionally, the CEO has the authority to delegate many of these powers and functions to other members of the agency's staff, which is, essential for the efficient operation of such a large and complex scheme.
What are some of the key areas where the CEO exercises these significant powers? The handbook specifically mentions powers that are relevant to both access requests getting into the scheme and the provision of participant supports.
Absolutely. In the area of access requests, the CEO holds the fundamental power to make the initial and often critical decision of whether or not a prospective participant actually meets the eligibility criteria that we discussed in detail right at the very beginning of our deep dive.
Right, the gatekeeper role, in a sense.
In a way, yes. When it comes to participant supports, the CEO is responsible for formally approving a participant's individual NDIS plan, including that crucial statement of supports and the allocation of funding. They also have ongoing powers to review a participant's plan at various points and, if necessary, to replace an existing plan with a revised one based on changing needs or circumstances.
The handbook also specifically details the CEO's inquiry powers. What exactly does this entail, and why are these powers important for the agency?
Right, these inquiry powers are quite significant. They grant the CEO the authority to formally request information or to require the production of specific documents from a really wide range of individuals and entities.
Like who?
This includes current participants, prospective participants who are seeking to join the scheme, and other relevant persons or organizations like providers, for example.
Okay.
The purpose of these powers is to enable the CEO to gather the necessary information for a number of important reasons.
Mm-hmm.
This includes things like thoroughly assessing whether someone meets the eligibility criteria to become a participant,
Mm-hmm.
effectively preparing or reviewing a participant's individual NDIS plan, carefully monitoring the supports that are being funded or provided to participants, investigating any potential instances of misuse or fraudulent activity involving NDIS funds, very important,
Yeah.
and assessing whether registered NDIS providers are complying with the relevant conditions of their registration. These powers also extend to generally carrying out the overall functions and responsibilities of the National Disability Insurance Agency.
So the CEO has the authority to ask for information if it's related to these various aspects of the NDIS. Are there any limitations or specific procedures that the CEO needs to follow when exercising these inquiry powers? They can't just demand anything, presumably.
No, there are important procedural safeguards in place. The CEO is generally required to provide at least 14 days advance written notice to the person or entity from whom the information or documents are being requested.
14 days notice. Okay.
Yeah. This formal notice must clearly and specifically state the exact nation of the information or the particular documents that are required, and it must clearly outline the specific purpose for which the information or documents are being sought by the CEO, so they have to justify the request.
Can individuals or organizations simply refuse to provide this information if the CEO makes such a request under these inquiry powers? Are there any legal obligations to comply?
Generally speaking, state and territory laws do not prevent a person from providing information, producing a document, or giving evidence if the CEO of the NDIS agency formally requires them to do so for the legitimate purposes of the NDIS Act.
Okay.
However, there is an important legal exception to this. A person is not legally required to provide the requested information or document if doing so would actually result in him contravening a law of the Commonwealth of Australia. Federal law trumps.
Right.
Additionally, the NDIS rules have the potential to specify certain state or territory laws that would prevent a person from having to comply with a CEO information request, although our current source material doesn't mention any such specific rules being in place right now.
It's interesting to see how the NDIS legal framework interacts with other levels of legislation in this way. The handbook also makes a point of reiterating, we touched on this earlier, that the NDIS agency is not permitted to fund legal assistance for participants or prospective participants who are seeking a review of decisions made under the Act. I imagine the CEO's powers play a significant role in those initial decisions that might then be subject to review.
That's absolutely correct. The CEO, or their delegates within the agency, is the primary decision maker for many of the initial determinations that can subsequently be subject to an internal review and potentially further appeal to the AAT.
Mm-hmm.
The fact that the agency is legally prohibited from funding legal assistance for these review processes really underscores the importance of participants, or their advocates, understanding their rights within the system and the various review mechanisms that are available to them if they disagree with a decision. They often have to navigate it themselves or find other support.
So it's clear that the CEO of the National Disability Insurance Agency holds quite significant authority in overseeing the administration of the NDIS, ranging from making crucial decisions about who can access the scheme to managing the ongoing implementation of participant plans and ensuring the overall integrity of the system through these defined inquiry powers.
Precisely. The CEO, operating under the strategic guidance and direction of the agency's board, is absolutely central to the day-to-day administration and the effective functioning of the entire National Disability Insurance Scheme. Their powers are specifically designed to enable them to carry out the very complex and multifaceted tasks involved in providing support to hundreds of thousands of Australians with disability.
This has been an incredibly informative and, well, truly comprehensive deep dive into the National Disability Insurance Scheme Handbook. We've covered a vast amount of critical information today, haven't we? From navigating the initial hurdles of eligibility, really discussing extensively the complexities of age, residence, and disability or early intervention requirements, to understanding the intricacies of participants' individual plans, the wide range of supports that can be available, and the different ways funding is managed.
Yeah, we covered a lot.
We also explored the very important role and responsibilities of nominees, the essential protections around the privacy of personal information within the scheme, the formal avenues available for reviewing decisions, the specific and crucial considerations that apply to children participating in the NDIS, the various circumstances under which someone might cease to be a participant, and finally, just now, the broad and significant powers vested in the CEO of the agency. It's really clear how understanding the NDIS involves grasping the interconnectedness of all of these different elements and how they actually work together in practice.
Yes, it's certainly a comprehensive and at times quite intricate framework, but it's ultimately designed to provide individualized and tailored support to people with disability across Australia. Whether you are a person with disability yourself, a family member or carer providing support, or perhaps a professional advisor working in the sector, having a solid and detailed understanding of these core aspects is absolutely essential for effectively navigating the NDIS and ensuring that it operates as intended for the people it's meant to serve.
Mm.
We sincerely hope that this deep dive has helped to demystify some of the complexities of the scheme and perhaps empower you with the knowledge you need to engage with it more confidently.
Absolutely. And on that note, here's a final thought for you, the listener, to consider as you reflect on our extensive discussion today. Considering the detailed framework of the National Disability Insurance Scheme that we've just unpacked, how can individuals best advocate for their specific needs and preferences within this very structured system? And, perhaps just as importantly, what crucial role do ongoing reviews both of individual plans and potential broader reforms to the scheme itself play in ensuring that the NDIS remains truly responsive and effective in meeting the diverse and changing needs of all eligible Australians?
Good questions to ponder.
It's a complex landscape, definitely, but one that continues to evolve, and your informed engagement and understanding are incredibly vital. Thank you so much for joining us for this in-depth exploration.